Hello and welcome. Today we're diving into something really interesting, a law in India from 1966 that puts specific limits on the fundamental rights of police officers. It really brings up a critical question, doesn't it? What freedoms should be limited for the very people we entrust to keep us safe and maintain order?
So let's just jump right to the heart of it with a big question. Can a police officer actually go out and join a protest? You might think that's a simple yes or no, but it's really not. The answer is tangled up in this law that tries to weigh an officer's personal freedoms against their professional duty.
To really get a handle on the rules, we first got to understand the goal. What was this 1966 Act trying to achieve? Well, it was created with one core purpose in mind: to make sure there's discipline and that duties are carried out properly within the police forces.
And look, this isn't just my interpretation. This quote right here, it's pulled straight from the law's own preamble. It is the official justification for every single rule that follows. So it makes things crystal clear. Discipline and duty are priority number one. So, how does the law actually do this? Well, it's not about completely erasing the fundamental rights that every citizen gets under the Indian Constitution. Instead, it places very specific targeted restrictions on those rights, all to serve that primary goal of discipline and order.
All right, so what are these restrictions exactly? Let's get into the nitty-gritty, which is laid out in Section 3 of the Act. This is where it spells out precisely what a police officer is not allowed to do.
Okay, but before we jump into the list, there's one really important word we need to nail down: sanction. In this context, it just means getting express, official permission from the government. So basically, think of it like this. Everything we're about to talk about is banned by default, unless an officer gets that official green light.
The things they can't do pretty much fall into three big buckets: who they can associate with, what they can publish, and which demonstrations they can take part in. Let's break each of those down.
First on the list, freedom of association. The law is very clear on this one. Police officers cannot join or be part of any trade union, labor union, or any kind of political group. There is a little exception, though. It doesn't apply to groups that are purely for social, recreational, or religious purposes.
Next up, freedom of speech. An officer can't just talk to the press or publish anything without getting that official sanction we just talked about. Now, there are a couple of key exceptions, like if it's a required part of their official duties, or if what they're writing is purely literary, artistic, or scientific.
And number 3, freedom of assembly. And this one directly answers that question we started with. Section 3, subsection 2 is very specific. It says, a member of a police force cannot participate in or even speak at any meeting or demonstration that's for political purposes. So, can a police officer join a protest? According to this act, the answer is a pretty clear no.
Okay, so we've got the restrictions down, but who exactly does this law cover? And, what happens if someone actually breaks these rules?
Well, the term police force is actually defined really broadly in this act. We're not just talking about your local city cops here. It applies to any force that's in charge of public order and is listed in the Act's official schedule.
And believe me, the scope is huge. The Act's schedule has this long list of organizations. We're talking everything from state police forces to central forces like the CRPF, paramilitary groups like the Assam Rifles, and even some investigative bodies. It's got a really, really wide reach.
So what happens if an officer goes against these restrictions? What are the consequences? Well, Section 4 of the Act lays out the penalties very clearly. And trust me, they're pretty significant.
Yeah, breaking this law is a serious offense. It's punishable with imprisonment for up to 2 years. That's a substantial penalty.
And on top of that, or maybe instead of jail time, an officer can also be fined up to 2,000 rupees. The law states the punishment can be imprisonment, a fine, or even both.
So, if we take a step back and look at the big picture, what is this law really all about? At its heart, it's a very deliberate balancing act. It's weighing two powerful and sometimes conflicting ideas: individual rights versus professional responsibility.
And that really is the core trade-off. On one side of the scale, you have the fundamental rights that every single citizen is entitled to. But on the other side, you have the needs of a disciplined force that absolutely has to remain impartial to maintain public order. This 1966 Act, it makes a very clear choice. It decides to limit certain individual rights in order to prioritize the integrity of the institution as a whole.
So we'll end on this thought. This act from 1966 gives us one answer, but it's a question that societies all over the world are constantly grappling with. How do you balance the rights of the very people who protect us, while also making sure they can perform their critical duties without political bias or internal division? It's an incredibly complex balance, and honestly, there are no easy answers.